Of
To start with, if that application were frivolous or vexatious, the court would not even want us to move it. And they tried to even prevent us from moving the application. The court said, you can't do that. This application is before me. It was filed since 2019. But that application constitutes the very fulcrum, the very substratum, the very linchpin of the entire criminal charge and criminal proceedings against Nnamdi Kanu. He is being tried here on certain counts, and the court continuously refused to grant him bail on the ground that the earlier bail granted to him, he jumped it. That application shows that Section 15 of the Extradition Act must come into play, which is that Nnamdi Kanu left Nigeria involuntarily when they were about to kill him and found himself abroad before he was renditioned back forcefully in a most gruesome manner under torture on the 26th of June, 2021. That application shows from exhibits MNK1 to MNK8 the circumstances under which he escaped from Nigeria, not jumpy bail. Exhibit MNK1, for example, is an affidavit he deposed to in the Holy See in Israel, where he gave facts as to how he found himself there. This is because in September 2017, I think precisely on the 14th of September 2017, Nnamdi Kanu was with his father, His Royal Majesty, the traditional ruler of Afaruku, Ibeku, Umuahia, Abia State, when the military invaded their house in the name of Operation Python Dance. I haven't seen Operation Python Dance at Sambisa Forest, dance at Chibok Forest, dance in Niger State, dance in Meduguri, dance in Kaduna. I have not seen, but Operation Python Dance went to a peaceful home inhabited by a traditional ruler, invaded it and mauled down 28 Nigerians, 28 innocent Nigerians in cold blood, gruesomely, in a most torturous and murderous manner. They did nothing wrong. Nnamdi Kanu, by the whiskers, like the cat with 9 lives, proverbially, he was able to escape. Then you say that person jumped bail. And it is based on that so-called jumping bail that even some of the counts they have tried to amend are still coming up. And all their opposition to bail application, contrary to Section 36 of the Constitution, contrary to the presumption of innocence on the part of every accused person, since our criminal justice system is Anglo-Saxon based, presumption of innocence, and not presumption of guilt, which is the French model, which is accusatorial, which is inquisitorial. The Anglo-Saxon one is inquisitorial. Everything they have been doing is based on that. Today, the prosecution for the 7th time came forward. They wanted to again amend their charge. By the grace of God, last time, we had objected to the 15-count charge as being puerile, has been unsustainable, has been incapable of granting the court jurisdiction. The court heard us loud and clear. During the last adjournment date, the court struck out 8 of the 15 count charge, leaving only 7. He said to them to lick their wounds, and come back quietly today for a trial. Yesterday, at 2:32 p.m., less than 24 hours to the hearing of today, they came back again with a so-called proposed amended charge number 7. And I told the court, you cannot carry out trial by ambush. This is the 7th time you are doing this. You are federal government. You have all the equipment, all the implements, all the facilities at your disposal. How come you cannot prosecute a simple case like this? That each time we are coming to court, a day before the court, you will dump on us. You saw the huge bundles. Each of them is as fat as a portmanteau or a briefcase that they dumped on us. I, speaking honestly as a Christian, have not even looked at the amended charge, not to talk of the documents they attach, which are bundles. The client, the defendant, Nnamdi Kanu, does not even know what they are coming with. And guess what? Instead of the 7 count charge that the judge left, on their own volition, they removed one again and brought only 6 counts, no longer 7 counts. So we beat them back again with bare knuckles. They brought only 6 today. Then I told the court, the way to go about it is that if they want this count, a plea to be taken. I mean, a plea has to be taken because this is a totally new charge. They changed many of the wordings, many of the sentences, and as quickly observed by my learned friend here, because I have not even seen them. Justice is not a one-way traffic for the prosecution alone. The Supreme Court, through Justice Oputa, said it is not even a two-way traffic for the prosecution and the defendant. He said justice is a 3-way traffic. Justice for the prosecution or plaintiff, justice for the accused or defendant, and justice for the general public, members of the public, the society, which is watching, as all of you were in the court watching. Can justice be said to have been done in this case? If so, is it manifestly seen to have been done? That is the question you will be asking yourself. But what they have always done in the name of trying to prosecute the defendant is to try to overreach us, try to ambush us, and today we resisted that ambush. And again, the court saw with us. I said, you can't do this. You continue to say, under the ACJA, the prosecution can always amend his count as many times as possible, even on the day of judgment. ACJA, for God's sake, is an inferior law subject to the Constitution of the Federal Republic of Nigeria. It is a mere act of parliament. The Constitution is the ground norm, the font origo. In the hierarchy of law, it is the master law. That is why I regard the Constitution as the Oba, the Eze, and the Emir of our laws. Other laws like ACJA are inferior laws made by National Assembly. They are like ballet or district heads. So what happens when there's a conflict between these laws like ACJA and the Constitution? The Constitution tells us, Section 1, subsection 1, say this Constitution is supreme. Supreme. And then it goes on in Section 1, subsection 3 to say, if any other law is still consistent with the provisions of the Constitution, that other law will be void to the extent of the inconsistency. So each time they mount this ACJA, who the judge from the bench today observed has many contradictory provisions. In fact, the ACJA, if you look at it, almost forgot the Federal High Court. They now first started saying FCT High Court before they remember Federal High Court. It should be Federal High Court before FCT High Court or any other court. Now, that Any provision in ACJA must bow to Section 36 of the 1999 Constitution, which gives fair hearing to an accused person. And what is fair hearing? The Supreme Court tells us that fair hearing includes fair trial. And that the two doctrines, the twin pillars of natural justice must be observed. One is nemo judex in causa sua. No one must be a judge in his own cause. The other one is audi alteram partem. You must hear the other side, which is why God gave Adam and Eve a fair hearing in the Garden of Eden, even after seeing the sins they were committing, being omniscient, omnipresent, and omnipotent. Now, what do we see? Nnamdi Kanu is being denied of basic facilities that allow for a fair trial. We lawyers cannot liaise with him and have interaction, pre-trial conferences. That was why the judge called the director of legal services today. I said, give them a conducive place and environment for them to carry out pre-trial conference. The small room where they allow us to come into, with our shoes be removed, this virus be removed, everything up to your pockets, up to this my handkerchief removed, everything removed. You don't allow me to take in a paper. You finally bring Nnamdi Kanu for us to discuss. What are we going to discuss without a single paper, without allowing us to talk with him, without showing him the charge? Not only that, the rooms are fully bugged and they shot themselves in the foot because in the amended charge proposed, which I forced them to withdraw today. Oh, by the way, they were forced to withdraw that amended charge. So it became as dead as dodo, dead on arrival. In that amended charge, you will see some of the proof of evidence, some of the documents where they put pictures of lawyers who went to consult with Nnamdi Kanu. So nothing is secret. There can be no fair trial when you are listening to the discussion between a lawyer and his client, in spite of the relationship, which is uberima fidei, utmost good faith, banker, customer, clergy, congregation, accountant, client, doctor, patient, lawyer, client. The relationship is sacrosanct, must be observed. That is one. Two, you are talking about try. Nnamdi Kanu undergoes solitary isolation. He's brought out once in a week to walk around and receive sun. Whereas medically, we must receive sun, vitamin D, every day. He cannot greet his fellow detainees because when they greet him, those detainees are taken to special cells for daring to exchange greetings with Nnamdi Kanu. So he is a solitary, sad figure. Don't you know you can be solitary even inside the market? So he's kept in a small cell where he cannot talk, cannot see people. He's not allowed to practice his Jewish religion. He's not allowed to wear the Jewish clothes. He's not given the Jewish mat to pray upon. And you are talking about a fair trial? The food that you used to give to him, you are not giving him the right quantity. You are not giving him proteinous or nutritious food. He's sick. He has begged and begged. We all have begged and begged to allow his own doctor come and give a second opinion of his illness. You are not allowing him. We are complaining about too much potassium in his system. You are not allowing another medical doctor. His father-in-law will come and look for him. You are not allowing him. I, the leader of the team, the lead counsel, I will want to see him. You will disallow me on more than 3 occasions. I've only been allowed to see Nnamdi Kanu in detention only 2 times. Me, at times I will now call the director of legal services, call all of them to help out. What manner of trial? So we have brought it to the attention of the court. So the application therefore moved today is at the root of the entire trial. When we succeed in it by God's grace, you will see that this trial is dead, and dead as dodo. And by the way, even the 7-count charge, after we forced them to withdraw the proposed amended 6-count charge, even the 7-count charge that now remained, we have again appealed against it to the Court of Appeal. And they are going to see, as we saw in FRN versus Saraki and Saraki versus FRN, where some counts were, where the Saraki had been discharged and acquitted by the Code of Conduct Tribunal, and they appealed. And then the Court of Appeal discharged him on some and retained some. He further appealed to the Supreme Court, which quashed all the counts. The 6 counts or 7 counts remaining now cannot even remain, because each of them is symbiotically and umbilically related with the 8 counts that were struck out. You are saying Nnamdi Kanu made a statement. How? Where? You didn't put the locus, the place where he allegedly made a statement. Under the Federal High Court Act, when you are charging a person under Act, you must state the place where the person allegedly committed the offense. Where did he commit the offense? If it was in the spirit world or underground, you tell us. If it was in Afghanistan, you tell us. Do you know why? They tried to run away after we had beaten them back in an earlier charge where we said, you say he made a statement in London. This court does not have global jurisdiction extensively up to London. They now thought that by removing London and just saying he made a statement, they didn't know they had run into more murky waters. Where did he make the statement for? Nowadays, with this technology, where I can be speaking and will be speaking with a female voice, because they will give me a female voice and you will dress me up in female clothes. So that is where you are saying that somebody made a statement from a place unknown, and that the statement led to people demonstrating in Nigeria and then leading to mayhem. I hope they will be able to bring up to, Nigeria is a country of 250 million people by last projection. I hope they will be able to bring at least maybe 50,000 witnesses who will say they were made to demonstrate because of a statement allegedly made by Nnamdi Kanu. I hope they will be able to. If they cannot, I'm afraid that even going to the merits of this trial, they will just be wasting their time. So the best thing is for this court to discharge and acquit the defendant, allow him to go in peace, and allow the federal government face more important things of insurgency, corruption, anger, hunger, abject penury, lack of infrastructures, fuel scarcity, diesel scarcity, education collapse, ASU strike, lack of mutual respect, lack of social justice, lack of egalitarianism. These are critical issues that the federal government should be facing. Not for a young man who is saying, if you are seeing me continuously as a dot in the cycle, and you are not respecting my rights, and you are not allowing Gowon's 3 R's, reconstruction, rehabilitation, and reconciliation, which were enunciated in January 1970, when the Civil War ended, and General Philip Effiong handed over the mantle of surrender on behalf of the Biafrans to General Olusegun Obasanjo on behalf of Nigeria. If you are not allowing us to at least be a part of your security architecture or apparatus, if you are not allowing us to be president of Nigeria after Aguiyi Ironsi, who only ruled for 6 months, if you are now allowing us to even be ordinary vice president, apart from Dr. Alese Kweme, that was vice president to Aliyu Shehu Usman Shagari, then let us go in peace. It is recognized. Self-actualization, self-independence, self-determination is recognized by the International Covenant on social and political rights, the rights of indigenous people, the International Human Rights Declaration of 1948, the African Charter on Human and People's Rights, self-determination. It's not a crime. So that is what this young man is fighting for. He hasn't carried guns and ammunition. We saw IPOB marching on the street, blowing whistle, wearing green beret. We want a Republic of Biafra. How is that amounting to treason or treasonable felony or offenses close to treason? What have you done about Boko Haram that are killing people, even in their bedrooms, raping women, wives, mothers, daughters, in men's farms, where our streets have become unsafe? What have you done about it? What did you do about kidnappers, armed bandits, and Boko Haram, challenging the sovereignty and sovereignty of Nigeria, planting their flags in many local government areas in Borno State and Niger State, and giving passes to people before they can pass through, imposing taxation? What did you do about it? When non-state actors are challenging your sovereignty and your sovereignty as an independent country by using equal and even more violent acts of violence, what have you done about that? Why is it this young, white, gray-haired man, who is as innocent as a dove, that you are deploying your arsenal? The trial is coming up today. Now you can see that they have blocked all the streets, so kilometers away. Over what? Over a young man who never carried a gun for one day. In all the charges, you never say you saw him with a gun or even a knife. No, none of them. None of them said they ever saw him coming on the streets. Even on that military, we were on the streets demonstrating, telling people, come with us, come along with us. Myself, Chief Ganifa, and me, and others. Even the military still permitted us at times to demonstrate. They didn't charge us with treason or treasonable felony. Then this is a democratic setup. Hello. Finally, let me say this. Abraham Lincoln, it was, who?
Hi everyone, how are you? I hope you're doing well. Our guest has something to say. Let's listen to that.